Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with signatures and who is signing what. So if you are an agent, whether you are on the listing side of a transaction or even the buying side of a transaction, it is incumbent upon you to make sure that you know that the person who is signing the contract has the authority to sign the contract. So in general, this really should not be an issue, but it tends to be an issue or could potentially be an issue if you have a situation where you are dealing with an estate, if you are dealing with any kind of a trust, if you are dealing with a power of attorney. So when you are, just in general, let's back up. If you are taking a listing, you definitely want to look up the records and see who is on the title of that property that you are listing, and then make sure that that is the person that is signing it. If you are helping a buyer buy a contract, you may want to make it a point of practice just to do a quick search again through the titles, wherever you have access to the titles, whether it be through the county, the online county courthouse records, through an attorney, through gsccca.org, through Realist. Realist is not necessarily 100% current. But regardless, wherever it is that you do check to see that the person who owns the house, if you're working with a buyer, you might want to run a quick check and make sure that the person on the signing the contract is in fact the person on title. And if not, you'll have further questions to ask. So if you are dealing with somebody, regardless of which side of the contract you are on, if you are dealing with somebody, let's start with an estate. If you are dealing with an estate issue, it may not necessarily be the person who signs the contract. You need to make sure that they do, in fact, have the authority to sign the contract, whether it be a listing agreement or a purchase and sale agreement or any documents related to the purchase and sale of the property. So Georgia is a probate state, and we've done several videos and have hosted several classes on dealing with estates. Excuse me, but Georgia is a probate state. So just because somebody passes away and in their will they leave the house to a child, a niece, a nephew, anybody else, if they leave it specifically in their will, that person does not necessarily automatically have the right to sell the property. The estate would have to go through the probate courts of Georgia, of the county where the person passed away, and then the probate court would deem who has the actual authority to sell that property. Sometimes it is somebody that was named in the will. Sometimes it could be an executor or executrix. Sometimes it could be that the probate court will assign an administrator. There's all sorts of things that have to happen. If it is a surviving spouse, it depends on the manner in which the spouse's had title to the property. If they had title with joint right of survivorship, then the surviving spouse would be able to sign the documents and sell the property. If they had title to the property as joint tenants in common, then again, that surviving spouse would not necessarily be able to sell the property without going through the probate courts. So that's just one example. In the case of a trust, there are all types of properties that are left to others in trust. Same thing. You will need to check with the attorney that set up the trust, or with the trust attorney, to determine who actually has the signing authority within the trustees and how they are to sign. A bigger issue, or a more common issue that you guys might run across, is power of attorney. Now, if somebody that owns the house is giving the power of attorney to sell that house or buy that house to somebody else, a couple of things. Number one, that power of attorney must be fully executed. Number two, the person that has the power of attorney must sign it in a manner that indicates that they are signing as the power of attorney for the actual owner. someone who has received power of attorney for somebody else cannot just simply sign their name, which might lead someone to believe that they were the owner of the house. They must sign it indicating they are the power of attorney for the person that owns the house. Typically, the attorney that does draft the power of attorney will instruct the person how to sign documents. And typically, it's person, receiver of POA, attorney in fact for actual owner or giver of POA, or receiver for owner. So again, check with the attorney who prepared the power of attorney to make sure of how they are to sign any documents. And you need to make sure that that power of attorney has in fact been executed before they can sign those documents on behalf of the owner. If the power of attorney is not in place, then you will need the actual owner's signatures. So again, just a quick contract tip, but a very important one. So definitely hope this helps you out. Please comment below if you would like to see more information on anything, for example, estates, trusts, land trusts, so forth and so on, or even power of attorney. I will get some more information, do some videos, or perhaps get some guest presenters, and definitely have workshops and classes at the Maximum One offices. So again, thank you so much for watching. Short and sweet today. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.